The next case to come before the court is in re CP. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. If you do plan to reserve time for rebuttal, please let me know as I'll be keeping track of time. Your arguments are being recorded, so please stay behind the podium. Keep your voices up. Introduce yourselves. You should not use the names of children or victims or minors in your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and we are ready to proceed when you are. Would you like to reserve time for rebuttal?
Yes, Your Honor. Michael Partlow, on behalf of appellant, I would like to reserve 5 minutes.
Very well. You may proceed when you are ready.
Thank you. Your Honors, this is a very, very lengthy case in terms of the procedure. So I thought I would lay that out for you from the very beginning, because that's one of the most confusing aspects of the case. It actually started out, courts, I should say, started out trying to deal with this child in divorce court across the street. The son of the Schwetters was married to the mother of the child in question. They were going through a divorce. An issue about paternity came up. Paternity was checked, and it was determined that indeed this was not his child. Now, by the time that this happened, the Schwetters had several years of exposure and experience with the child and had developed a very strong relationship. Ultimately, the court ordered a private investigator to be employed. A private investigator was employed, and Philip Carter was found to be the father. Once Mr. Carter entered into the scene, and now we're in juvenile court, the Schwetters, who had previously requested custody, backed off entirely. And the matter proceeded in juvenile court. Mr. Carter initially received custody because of a problem with mother's new, I think then boyfriend, but eventually husband. He was a registered sex offender, and the court did not want the child going around him. So Mr. Carter was given custody. At that point in time, he lived locally. There came a time when Mr. Carter and the rest of his family, because he is married, has other children, relocated down south. The summer visitation after the relocation was always an issue. And as Mr. Carter indicated in court, every time the child would come for a summer visit with her mother, some sort of motion would end up being filed, and the record bears that out. I was first involved with the case. Attorney Leslie Grasky had it before I did. I was first involved in the case with some motion practice that occurred when the child visited Ohio, not the last time, but the time before that. Then the next time rolls along, we make arrangements, and child comes to Ohio, and sure enough, they refused to send her back and file this motion. Now, we've raised 3 assignments of error, but I'd like to talk a little law first in terms of what is this court's standard of review. And this is where juvenile courts get a little bit sloppy sometimes, because the standard of review for a custody disposition, that decision, I agree, is abuse of discretion. But there are lots of appellate cases out there where they use the term abuse of discretion very freely. And in fact, if you're talking about a specific factual finding by a magistrate or a judge, abuse of discretion, I would submit, is not the standard of review. Judges and magistrates don't have discretion to decide things based upon evidence. They have to base their decision upon the evidence. So I would submit that it's an error to use abuse of discretion when you're talking about evidence. cases that talk about, you know, it must be supported by some credible evidence. Well, that's an old civil standard review that the Supreme Court of Ohio abandoned a few years ago. If we're talking about evidence, it's all manifest weight. And except for certain criminal cases where you do have a sufficiency question. But I would submit when the court's going through it, if what we're looking at is an evidentiary question, then that is a manifest weight determination. The precise way you do it is going to depend upon what the burden is at trial. If it's a clear, convincing burden, that's one thing. If it's a, you know, a standard weighing, that's another. The first assignment of error concerns the trial court's denial of father's motion to place the child with the Schwetters. There were competing motions here. Refusing to return the child, going into court ex parte, getting an order. The mother filed a motion for the child to be placed with someone I'm going to call Aunt Karen. Aunt Karen is, in fact, a relative of the mother. And Karen's an interesting character, as it was shown at trial, because she seems to be the default custodial parent for that whole extended family. This is, I believe, the third child that has been placed with her. Father, on the other hand, filed a motion for the child to be placed with the Schwetters. He explained his motivations in that regard, and I want to talk about them a little bit, because Father wasn't saying he thought the child should come back south. Father was saying, look, there's been all kinds of allegations against my family down south. We've had to deal with CSB for a period of several months. Even though that case was dismissed, I don't feel that it's best for the entire family for this child to return to my home on a full-time basis right now. Consequently, he requested that the child be placed with the Schwetters. Then an interesting thing happened. There started this evolution, shall we say, of desires by the child. You know, first she wanted to return home to her father's as long as she wasn't in trouble. Then she developed a problem with seeing the Schwetters, which the child had visited at the Schwetters' home without her father for, I believe, 1 week, it might have been 2, earlier that same summer, and had no problem with it. She had a great time. What the child wanted in this case was constantly changing. That was one fault I had. We had a very experienced guardian in this case. I recognize being a guardian is a tough job, so tough I won't do it anymore. But one thing that guardian attempted to do, I think, repeatedly, is cater to the wishes of the child. And I always questioned that. I mean, you know, if children of this age are going to be allowed to make custodial type decisions, that's crazy. Why do we need courts then? In domestic relations court, for example, even children that are much older are not allowed to make those decisions. They used to be, but not anymore. So I'm not saying we should ignore the desires of the child, but I am saying that, you know, they shouldn't govern things. One point of confusion throughout this case. When the case first started, we had a pretrial or whatever with the magistrate, and it first came to my attention that the magistrate was taking the position that there was a court order which prohibited any contact between the Schwetters and the child. And I didn't challenge him at that point. I mean, I needed to review the file, but I wasn't aware of any such order. I then began working with the guardian I don't want the court to think inaccurately of my relationship with the guardian. We could talk on the phone and work together just fine. Eventually, we both agreed that there was no such court order. What there was, and I think was being confused, several summers before that, there was a complaint by someone, presumably the mother, but I really can't say. Anyway, some fear that when the child came to Ohio to visit the mother, the Schwetters would try to see the child, things like that. There was an agreement reached at that point, an agreement that when the child's visiting with the mother in Ohio, the Schwetters do not have any contact. And that's what that order is about. Did I hear your order bell just go off?
It is going off right now.
Okay, well, I'll address my further remarks in rebuttal. Thank you.
Very well.
Thank you, Your Honors. May it please the court. Attorney Angie Killey on behalf of the appellee mother, Christina Jacobson. The issue for the court today is whether or not the trial court abused its discretion when making a decision to place this, that it was in the best interest of this child to be placed in legal custody of her maternal great aunt, Karen Kopak. Your Honor, I understand that the appellant has made some arguments in regards to differing areas, but I think that in this jurisdiction, the law is fairly clear that when a child is being placed with a non-relative, that the standard that the court is supposed to review is what is in the best interest of that child. And what's in the best interest of that child, although there isn't any specific test, shall we say, has some factors that are clearly delineated in 2151-414, and case law also supports the idea of looking to the additional statute of 3109-04 for guidance, and there is a catch-all phrase. I think that there is obviously a very long history, factually and procedure in this case. It was going on for a very long time. There were a lot of referrals to children's services, a lot of them unsubstantiated, a lot of back and forth, a lot of accusations, but when push came down to shove, the court, the agency, and the guardian ad litem all felt like placement in the custody of Ms. Kopak was what was in the best interest of this child. It's what the child wanted. It's what she had, the placement that she had been in, since there had been issues that had caused an emergency order to be issued by the court. Once she was in that placement, there was no indication that she wasn't being cared for appropriately, that she wasn't happy, that she wasn't having visitation with her mother in an appropriate fashion. All of these allegations that have been tossed around, I think, kind of murky the water to the reality of the situation that we have two parents of this child, one agreeably, my client, inappropriate due to her choice to marry somebody who is a registered sex offender. Father, not appropriate because he chose that he no longer wants this child in that home. When that comes down, then the juvenile court is the one that's in the position to make those determinations of who is the best party to care for this child. It's not always a question of, is there only one person that's appropriate to care for this child? It's who is in the best interest. She had a relative who stepped up. She's loving, appropriate, has a home. She was reviewed by the agency, and nobody had any issues with the way that she was handling any of the supervision or the care and day-to-day routine for this child. I think one of the biggest issues, in my opinion, that the trial court looked at in making their determination was the fact that the child had some medical concerns that needed to be addressed. Those medical concerns were effectively ignored, it sounded like, by father when she was in Virginia with him. When she came back, Ms. Kopak immediately sought out medical treatment, psychiatric treatment if it was needed, got the child in counseling, got the child referrals to different physicians, and got the child's situation under control so it would no longer cause her any embarrassment when she was in school. And during the course of the trial, one of the things that was glaring to me is that the other parties questioned whether or not that was actually even a real issue. And the reality of the situation is, by the time this hearing came for trial, by the time this child was even placed in emergency temporary custody of Ms. Kopak, she had had no contact with the Schwetters for a significant amount of time. She did not want to return or be in their custody. She indicated that she didn't even want to visit. And although the child's wishes shouldn't be 100% determinative of what's happening, The law clearly says that it's something that needs to be taken into consideration, and there needs to be consideration given to whether or not that child has a long-term relationship. And it's clear from the testimony that Ms. Kopak has been a part of this child's life since birth, even though she wasn't a custodian. She's always had a relationship and visited with her. And she didn't step up until father removed himself from the situation. This really kind of exploded once father stepped back, and then there were two appropriate parties. But I believe that if the court is following the abuse of discretion standard in reviewing what the trial court did, both the magistrate as well as Judge Teodosio, when they reviewed this initially and during the objection, made very specific factual findings and determinations of why they felt that this decision was what was in the best interest of this child. And that being the case, I feel that there absolutely was no abuse of discretion. It was not an arbitrary decision that was made without any factual basis to support it. And it is something that is a permanent, long-term placement for this child. Honestly, it's unfortunate that we're here and that the parties couldn't all figure out a way to get along so that everybody could participate in this child's life. But as it stands, I think that the decision of the trial court was very well thought out, very well articulated, and that it should hold up under this court's review as an abuse of discretion. If there are no questions of the rest, I will just rest on them.
You have no comments about the visitation orders in this case that have been appealed?
As the visitation orders,
Well, it seemed to me there are two assignments of error regarding the visitation orders. One, that the order for your client, I understand you represent mine, should be supervised by two people at once rather than one. As I understand, that's the objection that appellant has made.
that is one of the arguments that appellant made. I feel as though all of the arguments that the appellant made fall under the same standard because the visitation is a derivative of the custody determination, so it would still be an abuse of discretion. And no, I don't feel that it's unreasonable for the court to say that she doesn't need two supervisors.
Why did you have two supervisors at one point in time? Were you involved in the case then?
I was not trial counsel. It is my understanding from what trial counsel.
If you weren't involved, that's we can.
I was not.
I'm gonna ask you to comment on things you weren't involved with.
Fair enough. I believe that should be clear in the record though somewhere for the court if it's
And
necessary.
regarding appellant's visitation,
Yes.
I think one of your co-appellees, I think, makes the argument that he was ordered to have, in the judge's order it says he'll have video Zoom type visitation, and doesn't comment on what the summer visits will be, but the magistrate's decision indicated that he could have summer visits here during the summer in Ohio.
Okay.
Do you believe that the trial court's order, when it says, I think in paragraph 9, all other existing orders shall stay in full force and effect, do you believe that summer visitation order would still be in full force and effect for appellant in this case, if the judge had specifically indicated what would happen in summer visits?
And I want to make sure that I understand. That was a long question. I'm sorry.
Well, that's okay. I'm trying to figure out what the arguments were too, so.
I believe that what the court issued was that there should be summer visitation in Ohio in this decision, correct?
The court being Judge Teodosio did not specifically say that. I believe her order was there shall be Zoom, telephonic type visitation with the child. Didn't say anything about summer one way or the other. Did say in one of the sections, any previous order not contradicted by this order type of language shall remain in full force and effect.
I would be of the opinion that whatever is specified for visitation for the father in Judge Teodosio's decision is the final order of the court, because I would think that any additional visitation orders that had taken place would then be dismissed by that because they would be in conflict with what she's saying.
Very good, thank you.
Anything else? No? Okay.
Thank you.
Thank you.
I must respectfully disagree with opposing counsel. Done a lot of custody cases, visitation cases. When you put on a new visitation order, it governs. It wipes out any old visitation order. And I guarantee you, that's what would happen here. Now, even.
I think that's what she's saying. She's saying that we just look at Judge Adels's order.
Right,
That set up, as I recall, Zoom, telephonic type visitation,
right,
had no other type of visitation. So I think
Right.
she's saying, we would just look at Judge Adels's order, and we won't look at those previous magistrate decisions on guiding any other type of visitation to your client.
right.
I think it's one of the appellees who made that argument, not counsel here, so they're not here for me to ask that question of what they're saying. So your position also is, we're just looking at Judge Adels's order for what your client's visitation is, that's it, period, and there's no other further visitation for your client.
Absolutely, and talk about weight of the evidence, nobody addressed this at trial. Nobody said father should not have personal contact with the child. And in fact, it came up about, there was a request made that father make arrangements for personal contact and bring the step-siblings, which father said, that's no problem, if we're visiting at the Schwetters, I am not taking my other children, the Aunt Karen's, it's not gonna happen.
If you would address the issue of your client's visitation then for me, please, in your
I'm sorry?
objection. If you would address the issue of your assignment of error regarding your client's visitation, and why you believe that's an abuse. I believe that's your third assignment of error.
The third assignment of error was.
Companionship time with the minor child is not in the best interest. Were you objecting to your client's companionship time?
I was objecting, well, I was addressing both, okay? And if I strictly address the court order, like I said, there's nothing there. I had a problem with the magistrate's decision too, because the magistrate essentially said, if, the father and Aunt Karen have to come to an agreement about the summer visitation, and then the default is this common ground place, which I'm not familiar with, but I understand what they do. And I had a problem with that because, and this comes through in the transcript on many occasions, there is no relationship between father and Aunt Karen. I mean, he knew she was, that's about it. So it's not like they can overcome this familial animosity that is pretty obviously there. With regard to the medical issue and the child, I admit there were problems there from both sides. There was a question about how much the father knew, et cetera, et cetera. But bottom line is, and I admire the guardian for this because very few guardians will actually do this, but her position changed. Even after what was to be her final report, she amended that. Once she found out that the condition was under control and that there was no real danger to the child as long as father's visitations were kept to a week or so, she had no problem with summer visitation with father for that period of time. So the medical issue was addressed. As far as the two supervisors, I don't want to make it seem overly simple. That was reached by agreement, okay? I believe it was the prior visit. I could be wrong about that, but the prior summer visit. And then that was reaffirmed with this summer visit. And the reason for that is there was some issues in the past, long in the past, but in the past, about Aunt Karen's supervision was a little bit loose with mom, which would give the stepfather an opportunity to be around the child. There was that. Combined with the fact that the second set of supervisors, another aunt and uncle, actually didn't really want to be alone with the child. They didn't trust the child. So we came up with this, okay, well, if the child's going to leave Aunt Karen's residence, then both of those have to be present to supervise. I'm not sure that that's really in the record at all, but that's what happened. Thank you, Your Honors.
Thank you. And thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. The court is now adjourned